Hand over this.
Your Lordship, may I mention one matter for upgradation, Your Lordship? The date has been fixed in the trial court in a Monday, Your Lordship.
Mention on Wednesday. Yes, call the list.
Item number 1.
But I appear for the petitioner with the written notes of submissions.
Your Lordship also asked Mr. Mitra to
Yes, where is Mr. Mitro?
But he's on his way. My lord, possibly we had asked our clients, my lord, there's two possible setbacks, my lord, because the new season has already started. And my lord, the contracts of the players have already expired on 31st of May.
So it's not possible.
Not possible. That is why, my lord, we have already
season has started, so there is no urgency for them at all.
Strategy, if their instruction is that. Yes, Mr. Mukherjee, anything?
Written notes.
If they.
So they don't have any urgency anymore, my lord, because the new season has already started.
Your Lordship had the matter, my lord. Now, my lord, Your Lordship, on the query whether there is a chance of settlement, my lord, that is
Given the written notice.
Yes, yes. No difficulty. Ashun. The petitioner.
Players, my lord, of the earlier season cannot now play.
saving.
Yes, thank you.
My players are all the same. There is no problem.
I do not know.
I'm not
So
sure.
this was only not with regard to the merits, anything if can be done.
So that's true.
Yes, Mr. Chatterjee, please appear when the forwarders matter will come. Because I require your presence.
I don't know for what, my lord. I hope it's for something good. I hope and pray. But
And if you can inform Mr. Kaur if he is also present. If he can remain present. Yes, call the next
matter
matter.
is also there, my lord. So the X matter is also the same. So they must be appeared.
Which matter?
Item number 16. One your lordship is talking about.
Yes, yes.
16 is also part of that.
Yes.
So they will be appeared. I'll also
Also,
inform
please
Mr.
inform
Kaur.
if Mr. Kaur appears. Yes. Yes, call the next matter.
Item number 3.
আমি তো কিছুই করছি না, আমি ঠিক বুঝতে পারছি না।
Lordship, this is my application for extension of interim order dated 19 March 2024, last extended on 17th of December 2024 till yesterday, my lord. My CAN 3 is my application for extension, my lord.
Yes,
I'm filing my FDR service also, your lordship.
if your service, they have been served.
My lord.
If your service.
For the petitioner, my lord, in this matter, the affidavit of service has already been filed. However, my lord, the intimation regarding, my lord, the mentioning, since, my lord, none appears on behalf of the opposite party, I have informed the learned advocate appearing in the trial court through WhatsApp as well as sent the intimation through post.
Mr. Bhattacharjee, Learned Senior Advocate appearing. What is, you are filing today?
This is the third time. This is the third.
This is the filing today.
No. This is the
This
earlier.
was earlier.
Yes.
item number
ও এটা আগের ম্যাটারের এভিডেন্স সার্ভিস তোলেননি, আগের ম্যাটারের এভিডেন্স সার্ভিস, এইটার নয়।
Interim
Let's call the next matter.
item number 5.
expired yesterday, my lord.
My lord, I am appearing for the father.
Copy, my lord.
Yesterday, my lord, evening. My lord, I am appearing for the father, my lord. Your lordship may dispose it of, my lord. It's one, my lord, short legal question is involved, my lord, whether Order 7, Rule 11 application is maintainable in a application filed by the father for custody. My lord, on the ground that the present residential accommodation of the child is with the mother, who is outside the jurisdiction of the Alipur court. My lord,
After hearing the learned advocates for the respective
and my lord,
parties.
one more thing, my lord, if your lordship kindly, since there are 4 litigations between the parties, my lord, one, my lord, by 2, my lord, by the husband, one Section 9 application under the Hindu Marriage Act, and one, my lord, this custody application, and they have filed, my lord, the usual 498 and the domestic violence, where I am paying 21,000 per month. My lord, the matter may be, my lord, referred to a mediation, my lord, if it can be.
Both of you agree, I have no difficulty.
Mediation is always welcome, my lord. I do not stand in the way.
Mr. Chatterjee, Mr.
My client,
Sure, if you, both of you
my lord,
agree,
my client has
But
given
Mr.
me
Chatterjee, have you taken
very lordship for-
instructions?
Because I've not taken instruction on that, but mediation is always welcome, my lord.
But unless your client agrees to that, I can
Yeah,
send this matter
there
to
are 4
mediation also.
Then I have to
litigations.
take instruction. Then I have to take
Well, then
instruction.
let him come at 2 p.m. my lord, if it
But
commends
as
to your
far as
lordship, my lord.
the-
Interim order is expired yesterday.
Interim order expired yesterday, but the
So
next
I'm
date
keeping
is
it tomorrow, take instructions.
Much
Nothing will happen in one day. When this matter is taken up for
I'm for the petitioner. I'm led by Mr. Siddhartha
Not to item 6, I'm for the opposite party.
yes, but for the opposite
I'm
party.
for the opposite party, my lord.
So this for extension of interim order.
Yes, your lordship.
So this is appearing in the list. The main matter is appearing in the list.
Yes, your lordship.
That's there in the list. কত নম্বর item বল?
Under
বল কত নম্বর item?
in the combined list. Motion.
Motion, lordship.
After hearing the learned advocates for the Mr. Banerjee.
This one will be in order, 25th March.
So doctor, have you served?
Yes, I have some.
Where is the evidence service?
They have given.
Affidavit of service filed.
I'm for the petitioner, Lordship. The interim order was till yesterday, Lordship. We have served, Lordship, but the consignment details was not found in the website, Lordship.
Then service is not complete.
Yes, Lordship kindly directs me to again serve, Lordship.
Why? What is the endorsement? The address is not correct. What's the
No, details is not found. Lordship, we tried to
the
give
consignment details is not found?
Yes. Maybe we tried to take this report after 30 days. That is why it was not
That is
available.
why it's not available.
Lordship, may I file the affidavit of service?
The affidavit service filing code today.
This is my application, my lord. I am the defendant in a suit where my amendment was, my lord, refused. I came up before your lordship. Your lordship passed an interim order which expired, my lord, on the last day of June. Lord, and I have, my lord,
Have you
effective
stopped?
service. Yes, my lord, all have received. There are 3 opposite parties who have received, my lord.
Amendment or
Amendment of
order
written statement.
829,
Additional written statement.
not amendment.
But it contains certain, my lord, amendment also, my lord, that.
Mr. Mukherjee, Lanet Senior. Yes.
My lordship, I am appearing on behalf of the petitioner. This is a transfer brief, my lordship. I have received the copy from the petitioner on yesterday. For that reason, my lordship, I am praying for 1 week's accommodation. And also I have found that the affidavit of service has not been prepared by the earlier advocate or
The learned advocate appearing for the petitioner.
11. Lord, once it was served, Lord, your lordship directed me to serve again. So far as one opposite party is concerned, opposite party number 1. Lord,
What happened? What is the endorsement?
here also it was written with left, same endorsement, left. But learned advocate was served, Lord. Pursuant to your lordship direction, learned advocate was his receipt.
The land, evidence service filing.
Will be extended.
November.
Matter is already in the list.
Your interim order be extended.
Item number 12. 12
Only.
File the
Sir, we have
Yes.
We have served big. Yeah.
Where is the evidence service?
Last occasion will have to spend. Last occasion it was spent.
Whom have you served?
Upon the opposite party.
Why the learned advocate has entered appearance? Why have you not served her? Piyashi Chakraborty.
We have no knowledge, my lord.
Yes.
In this.
There was a caveat also.
Who? No. There was no caveat.
Yes, there was a caveat.
I have no knowledge.
What do you have no knowledge?
I have no knowledge, my lord.
Please serve upon the learned advocate. It appears from the record that Miss Yes.
For the petitioner, if it is my affidavit of service, the petitioner had mailed the bank regarding the mentioning notice.
Yes.
Do not take me for a miss, my lord. Kindly see the order dated 16/5 order, my lord.
16/5.
16th May.
Is the impugned order?
No. My lord's order. ধরো তো
No settlement.
No
My
payment.
lord, the petitioners approached the bank, but they're coming up with a new notice every time, my lord. They've approached the bank is again.
Matter is appearing in the list.
Yes, but I'm only praying for extension interim order. Senior
Matter is appearing in the
in
list.
the list, my lord.
All right.
Only one request I had, my lord. Only one request, my lord. If my lord thinks fit.
It's appearing under the heading fixed matters.
Yes.
So, the interim order.
That is what they have wanted to file in the civil.
The interim order passed on 16th of May 2020.
Same.
No, it will like
Mr. Chatterjee, please come to page 207.
Point was taken in, let's say, application. Page 207.
Have you got page 207?
Yes, sir.
Please see the appearance of the learned advocates of the petitioners.
My lord.
You have seen.
Oh. It has a name.
Strategy, you have not got to my notice.
My fault. I'm so sorry. I'm so sorry. I'm so sorry. I am
Really
so
Because Mr. Kaur may have missed it, but
sorry, I
No,
never
no, no.
noticed it.
Even I.
that is why I said Mr. Kaur may have missed it. But
It's my completely my
the only thing, the matter was heard when I was
Kindly ignore this and
because
Mr. Kaur, it's difficult. It's difficult. Nobody knows what will happen subsequently. If I tell both of you that if it escaped my notice, yes. While I was going through the papers, when I was trying to go through this order under section, because much arguments were made on order 7, rule 11, then it struck me.
problem is, Willard, we didn't see the appearances at all. Though I should have
Because
remembered.
I also, but for
I
some
should have
reason,
I should have remembered because he was assisting me. There is no dispute on that. I can't get out of it.
But I'm really sorry that
no.
We are all, Willard,
The only difficulty is that some time has been wasted because the entire matter was hard.
much time.
That is why I gave you trouble. I requested both of you to appear.
I was wondering that he must have missed something.
Something in the matter. My lord looks into the appearances, Willard.
No. Mr. Chatterjee,
No, you
somehow came to, so there must be something which does not want that myself will decide this matter.
Actually, the entire matter was heard by a lordship, so we placed that order, but never
But we never
realized-
looked at the appearance at all.
Never looked at the appearance.
But it somehow, I noticed went to there.
We remember once, Willard, Justice Sanjeev Banerjee, Willard, Shuddha Sattva Banerjee was appearing. He said, ask him to return the brief. But here he was appearing at a time when he was, Willard, when your lordship was not taking up the matter. So it's not his fault, we should have pointed it out.
Actually, also, it
It
didn't
didn't
strike.
strike us.
Appearance that.
This matter was so
No, natural.
the
Lord,
in the weekend I was only going through the papers so that I can.
If your lordship had passed the order on that particular day itself, ঝামেলা মিটে যেত।
But item number 16.
Same thing.
That is also.
That then also it has to be. Item number 16, since I am not inclined to take up this matter on personal Yes, I will do it as soon as it comes.
Item number 50, I am the petitioner lordship.
Yes.
So grandfather of the petitioner lordships was the filed a suit for declaration and injunction lordship. During pendency of the suit lordship, he died. His legal heirs were substituted lordship and amend the plaint lordship. Then the plaintiff number 1 in the amended lordship, plaintiff number 2 again died lordship. Then the remaining 2 lordships, the learned advocate filed application to expand the name of the plaintiff number 1, but not file any application for substitution lordship. And that fact has not known by the legal heirs of the deceased plaintiff number 1 lordship. Subsequently, he came to know after inspection lordship, they are learned
legal heirs of the plaintiff number 1.
Yes, lordship. Thereafter, lordship, by the mistake on the part of the learned advocate, he filed application. In the meantime, the period for substitution lordship has already expired. They filed an application for oral and rule lordship.
Cannot be done.
Lordship, but it is admitted lordship. It is a mistake on the part of the learned advocate lordship.
So I can give you leave to file an appropriate application.
That liberty is
yes.
And lordship, one judgment as per the judgment of the Supreme Court lordship, this oral application should be treated as an application for substitution under order 22 lordship.
That can be provided there's a subsequent judgment also. Yes. After 2016, in 2025 there is a subsequent judgment. It's not the proposition, it's not disputed, but yes, provided order 1 rule 2 contains the reasons for setting aside abatement, then it can be done. If it contains the reason, yes.
Can you give me liberty to file up leave?
Where is your application under order 1 rule 10? Please.
Yes, lordship, page. Page lordship 31, 32, para 4, 5, I have stated lordship. When he come to know from the learned advocate, immediately he filed an application. But it is a mistake on the part of the learned advocate. He filed application under order 1 rule 10 lordship instead of order 22 lordship.
I think it's better if you take leave and file there.
Yes, lordship.
Or there will be a delay.
Yes, yes.
If they,
yeah, lordship,
because in the absence of the other side, I cannot pass.
Yes, lordship.
The learned advocate by the order
May it please your lordship.
Yes.
That's my affidavit of service, my lordship.
I've served upon the cavetus advocate. My lord, this application order relates to an application filed and a rejection of an order under Order 9, Rule 13.
Order 9, Rule 13 rejected by both courts.
Both courts. I'll come to that, my lord. But just in a nutshell, what's the matter about? I'll just say that. My lord, an eviction suit was filed in the year 2014 against two defendants.
Show me the finding.
Lordship.
Show me the finding of the
Appellate court.
Appellate court. This is the order of affirmance. Show me the appellate court order.
Lordship. May I read out the order, my lord?
Only the relevant portion.
Only the relevant portion. My lord.
The reasoning why it was rejected.
Lordship. Page 4, my lord.
Yes.
Para 8. From the factual matrix, it appears that both Shivalik Mistry and Alvin Mistry, defendant number 1 and 2 in ejectment suit number 98 of 2014, were tenants under respondent in respect of the suit property, and they were accepted as tenants after the date of their father, Maro Mistry, on 5/9/2007, who was the original recorded tenant, and the respondent filed the said eviction suit against both of them for the eviction from the suit premises on the ground prescribed in section 6(1) of the WPPTA Act. Admittedly, the said Shivalik Mistry, defendant number 1, died during the pendency of the suit, and since learned advocate representing the said Shivalik Mistry did not notify the name of his heirs and successors, his name was expunged, and the suit was proceeded against the defendant number 2, and it was decreed ex parte against defendant number 2. Now the question comes whether the present appellant is a necessary party to the said suit. My lord, the present appellant is the son of the deceased Shivalik Mistry. He was completely unaware of the suit being pending. He was completely in dark about the same. The moment the bailiff came to the decretal suit premises to take possession, he came to learn about the decree being passed, and then he appeared before the learned court, filed an application stating that he is the son and he has the right to be heard. That was not given. It is admitted that after the date of Maro Mistry, original tenant, said Shivalik Mistry and Arvind Mistry were accepted as tenant by the respondent.
Yes, is this the ground,
my lord,
for consideration of an application under Order 9, Rule 13?
My lord. Moreover, my lord, 140.
Kindly comes to page 23, my lord.
Show me the reasoning of the appellate courts. Can it be the reasoning for rejecting an application under Order 9, Rule 13?
I am not on that. Your lordship kindly comes to page 23.
On that. We have
has the applicant been able to establish before the court that he is the son of defendant number 1? Kindly comes to page 23, my lord. In order to take out the application for setting aside an ex parte decree, a person claims that he is the son of the deceased defendant whose name has been expunged.
Decree is nullity. Show me the decree, ex parte decree. Show me the ex parte decree.
That is not with me right now. If your lordship, I'll place it before your lordship, the ex parte decree.
Yes, where is the ex parte decree? Do you have a copy of the ex parte decree? So the decree was passed also against the dead person.
Yes.
No, he
has to be.
Yes, my lord.
Defendant number 2 was set ex parte. Defendant number 1 was expunged.
How can you expunge? At whose instance it was expunged?
My lord, a verified petition was...
Sir, please take your seat. At whose instance it was expunged? Under what provision of law he was expunged?
They cannot, I know.
Sir, then the decree is nullity. You take either way.
Your lordship kindly comes to page 23 once.
Sir, decree is nullity. How can that be expunged? Under what provision? Show me that you have complied. If not, then go.
Is not there.
Now, what do you propose?
But at the instance of the applicant,
carriage of proceeding lies with you. You ought to have taken steps. You ought to have substituted.
No, my lord.
See, the learned advocate did not. Learned advocate appearing for the defendant did not intimate the names of the heirs. That cannot be a ground. Carriage of proceeding lies with you. Show me the provision under the Civil Procedure Code which says that the learned advocate of a deceased party is required under the statute to disclose the names of the heirs. Show me that.
This is where I am, that the defendant number 1 was issueless. Insofar as my knowledge goes, because he was there in the premises, he was issueless. So there is a provision of appointment of someone as per the CPC that was not carried out. Then the name was expunged.
Then
And at the instance
If you
of the
want to make
applicant-
submissions, I will admit this. I will keep it for hearing.
Kindly comes to page 23 once, Your Lordship.
Yes,
Kindly.
yes.
This is the Aadhaar card of the applicant.
Sir, I cannot decide that. These are not the matters which have been decided.
I'm just indicating it. Your Lordship, kindly
Sir, I
see the
cannot
name.
go to that. I will also look at the finding. Show me from the finding
Kindly
that this
look
was
at the
the
name
finding.
first, my lord. Kindly look at the name. Who's the applicant and who's the father's name? What's the
Yes.
father's name?
Yes.
It's Satish Sharma and Shivalak Sharma. And who is the defendant number one? Shivalik Mistry. The death certificate has also been annexed. It's Shivalak Mistry.
Were these documents considered by the learned trial judge?
This is where I am.
Considered?
No, my lord.
It was
Then-
not.
Then,
They did not please.
then I'm setting aside. I'm restoring the order 9 rule 13. Let it be decided if you want that.
Kindly take up the matter tomorrow, Your Lordship. Let me go through.
Not tomorrow. It will come if you want a hearing. Ashu. After going through the Constitution of India.
that may be stayed during the period my application under Order 9 Rule 13 is under consideration.
That has to be,
Entire thing will be frustrated.
It's that evidence stayed. Let the evidence continue,
no.
Why?
and it will not be implemented.
no. Unnecessarily,
Then
with the decrease set aside,
Give
everything
the
goes.
process of
In
events
that
time.
event, let it be adjourned sine die till decision of
No.
this application.
There shall be an order of, now in view of matter.
On behalf of petitioner, my lord, I am praying for adjourn the matter today. Kindly fix the matter for tomorrow, my lord.
On the prayer of the learned
Small difficulty, request me over phone, my lord. Some medical emergencies for my lord, for fortnight adjournment, my lord. Subject to your lordship.
who is ill?
On
He is
your
senior, the junior.
he is junior member.
And yesterday an accommodation has been preferred on the ground of the senior. I asked him,
No,
I'm
not
giving.
me. No, I am not in this.
No, the learned advocate, where is he? Who appeared yesterday? Ask him to come. Oh, ask him to come.
I have to inform him by over phone. Yes, well,
Yes. Next.
Item number 20. This is my application.
Yes, Dr. Path.
Very small issue involved. We are praying for expeditious hearing. The matter is before the State Consumer Forum and repeated adjournments are being made. The opposite parties are not even appearing.
No, not appearing means served. They have been served or not served.
Yes, they are served. This has been going on for 7 years.
No. Service return. No. What is the last order?
Kindly see, they are attached at the
14th of August for final hearing.
Yes, but kindly see, learned counsel for the complainant is present, none appears for the OP. This was passed on 28th January.
15th of August, Dr. Patru, it has been fixed.
No, but kindly see the previous order. I've given the entire series. They're not coming.
If they do
Again,
not
it will
come,
be, again, it will be adjourned. It will not be heard. Kindly see. Learned advocate for the complainant is present, non-present for the OPs. This is 5th September 2024. Fixed on 28th.
this application under Article 227 of the for the state commission from the year 28. Yes, call the next matter. As you disposed of. Yes, next.
21, my lord, in this matter, lord, I am appealing for the plaintiff petitioner.
Yes.
The suit for declaration.
Why were not there, Mr. Rai, yesterday? This was taken up yesterday.
Yes, I know. Then Babu got 446.
Was taken up prior to
Yes, it was taken up. No, just last. I was there.
No. It was taken up prior to 3:30.
Not 330. I have 446. Court
Oh, court number.
and Babu
I
got.
was
That's why I am saying. And Babu got.
saying the time 4:46.
And Babu got.
Yes. Yes, what is this matter?
Suit for declaration recovery position. Man can turn to the prayer made.
What has been done?
Mandatory injunction granted without recovery of
That is
possession.
you are opposing.
This
Declaration and
matter, Mr. Chatterjee, is
declaration and
recovery of possession. And Madam kindly consider the what is the degree passed by the tribunal.
recovery of possession not directed.
Not directed.
Permanent injunction has been passed.
How I am admitting the possession is reversed with them. I want for recovery of possession, then my lord, how permanent injunction can be granted and only for mandatory injunction.
Show me your plaint.
Yes, my lord. Only turn to page 22. Page 23, my lord. বাকি পেজটা কোথায় গেল রে? ও কোথায় গেল? এই এখানে
Permanent injunction you have sought for.
permanent along with recovery of possession, Manoj Kali, permanent injunction, man, that is
So you are aggrieved by
not
permanent the recovery of possession.
and there is no scope for review with the tribunal.
No demolition. No, Mr. Rai, it has been passed. Yes, directed to demolish.
Injunction granted.
Restore the property to its. Yes. What more?
Unless it is recovery, Manoj Kali, it is a mandatory injunction for the purpose of demolition. Unless the recovery of possession, how permanent injunction can be granted? When I am admitting that they are in possession of the property.
So permanent injunction mandatory granted. Only the recovery of possession is there. Mr. Rai, is it necessary when the mandatory injunction is passed? Is it necessary to separate for recovery of possession?
Whether I can execute the degree, whether I can execute permanent injunction can be executed in
No, mandatory injunction is there.
for the demolition of the structure.
Yeah, Mr. Rai, there is a line of decisions which says mandatory injunction. Have you considered those?
Yes,
judgments?
mandatory injunction for the purpose of where
Demolition. Your allegation was that they should be restrained from making any construction, and some construction they have made. So you wanted mandatory injunction that has been granted. Property to be restored to its original
no,
condition.
that is the only thing Manoj Kali consider the
And your submission was that you are in possession. So this mandatory injunction, because your claim was that you are in possession, but they have encroached upon such portion.
I am in possession.
Yes.
I was in possession.
Yes.
I've been
So mandatory injunction is
for the removal of the obstruction. Now,
right. Is it necessary to pass a separate decree for recovery of possession in the case of this nature? Have you considered that?
Mandatory injunction, my lord, is of the opinion the mandatory injunction amounts to, my lord, the possession.
Have you considered the decisions? Whether a separate decree for recovery in the case of this nature is necessary or not?
Whether the permanent injunction can be granted when
No, permanent, you are not agreed by that. Permanent injunction not to construct, mandatory also granted.
Permanent injunction, my lord, what is the permanent injunction granted? That is why, my lord.
Permanent injunction is from transferring, alienating.
Hereby declare the property belongs to such and such, the remainder of
any third party.
creating any construction over the suit property and also restrained from transferring and alienating. So for my position.
What is the dispute? Who are the defendant numbers 1 to 4?
They are the trespassers. I have admitted them to be the trespassers. So once there is no permanent injunction against them, my security will be in position.
Mr. Rai, you may say that this does not give any benefit to you, this order. The other side may have a right to challenge that. But now with this mandatory injunction, whether with recovery is also necessary, what do you say to that?
This is when the trespassers enter into make construction. But in absence of recovery, barely bear mandatory injunction.
Because Mr. Rai, I'm not on that, because if it is kept pending, you cannot execute that also. Please apply your mind.
Yes, but I cannot get also for that.
That is why,
tried.
Mr. Rai, if you are entitled to put that decree into execution, so nothing remains. Otherwise, I have no difficulty in. That is the problem. Have you considered that?
Yes, why not Kali? Because they have demolished the building, but position they have
the petitioner, Mr. Rai, learned advocate appearing for the petitioner submits that the petitioner is aggrieved by refusal of the prayer for
Number 22.
But it's a little bit weird. But the suit is filed. The defendant below is the petitioner before your lordship in a suit for declaration that an agreement below is still binding.
defendant is the petitioner in a suit that the agreement is
binding. The agreement which
no
is
suit
there,
for specific performance of
for
contract.
specific performance of contract.
Yes, then
Injunction is allowed on the ground, my lord, that the other side is violating the order, ex parte. Then he puts that, my lord, order, my lord, into files an application under 151, praying for police help, and that has been allowed ex parte. Not ex parte. We were there. We went and asked for, my lord, we prayed for, please allow us to use an affidavit. Refused, passes an order, police help granted. I say, my lord, without section 36, this cannot in any way, my lord, even proceed for a day.
so according to you, these orders are to be executed.
And that's the
There is a decision, Mr. Chatterjee.
Yes.
It says that
it has
even
to be done in that manner. Justice Dipankar Datta, Justice Joyanto Vishwas, everybody has.
there are other views also. It says Justice Dotto also passed a judgment which says yes, 151 is also
When
maintainable.
all remedies are exhausted, it's only then, not before that. And here is a glaring case, my lord.
But
I am constructing on the basis of a High Court's order. My lord, this was a dilapidated building.
Mr. Chatterjee, have you filed any order 9 rule order 39 rule 4?
We have filed a Rule 7.
Order 39 rule 7 for local is no.
nine-
According to you, you have said that the ad interim order of injunction was passed. Have you
Filed
filed
an
any-
appeal.
What happened in that?
We just, my lord, it's pending now.
When the ad interim order was passed?
Finally, he has disposed of.
No, I was under the impression ad interim injunction.
Kindly have a look at it.
Then Mr. Chatterjee, it's better if it is on a contested hearing.
No,
Mr. Chatterjee,
contested, not contested. Kindly have a look.
You have said final.
Yes, but not contested. Kindly have a look at it.
Mr. Chatterjee, if you chose not to appear, what can be done?
It may appear. That's why I started off by saying it's weird. It's weird. Have a look at the order once.
Page.
Starts off from page 32. এটা কত নম্বর পেজ রে? Page go? 22. 8 Actually. Milord kindly turns to 21 first.
21.
Yes. Difference is it?
This is the ad interim.
No. Kindly see is below the first day. Defendants do not appear in spite of good service as per postal track report. Henceforth, the suit shall proceed ex parte against the defendants.
No.
This is the first
Where are you? Which page?
21, Milord.
Oh, 21. I was looking at 20.
I'm sorry.
Yes, 21.
Order
No,
number-
so page 20, so ad interim order of injunction was passed.
Yes. Yes.
So thereafter directions for service.
Rejected.
It was refused.
Considered and rejected.
Oh, sorry. Considered and rejected.
Rejected.
Yes, notice was directed to be issued thereafter.
Then on the next day, my lord,
Item delivered.
delivered, addressee for both the defendants, heard learned advocate for the plaintiff, ex parte.
Court can pass.
Can pass. Turns
Yes.
over. Today, the 151 prayed for ad interim injunction restraining to the
Page
defendant.
22.
22.
Yes.
My lord, your lordship
Now,
skips over.
what is this? This is the final hearing.
Yes, my lord. Kindly have a look at page 25, ordering portion.
Mr. Chatterjee, this is also till the next date. Why?
Exactly. That's exactly why I'm here before your lordship. The entire thing is a problem.
No. So what happened? You have prepared an appeal against this.
Yes. Then, my lord, what happens is he files a 151 application. That 151 application.
That is for police help.
Huh?
That is for police help.
Yes.
Yes. Where is that?
Kindly have a look at 26 once. And we appeared there and we file an order 9 rule 7.
What happened to order 9 rule 7?
Still pending. Still pending. Then what?
No, even Mr. Chatterjee, without that order 9 rule 7, you can participate in the proceedings from that stage itself.
Absolutely.
Nothing has been done prior to that, so you can proceed with that.
Very well. That is most important, my lord, that it falls from your lordship. Kindly looks to 151 now.
Page
128.
8. Yes.
My lord, this is the application.
Yes.
There is nothing on record how I have violated it. They are saying I am obstructing in various ways the usual activities of the plaintiff to discharge their obligation pursuant to the agreement dated 24th of
Mr.
December.
Chatterjee, if there's an order of status quo with regard to nature character also, nothing can be done.
No,
so
my lord,
police can be directed.
My lord,
They can
this
do
is a
one thing.
circuitous way of getting into possession. My lord, I am in possession. I am giving an undertaking I will not construct, though there is a high court order that I will not construct. Here, it is being allowed on the ground that I am violating it. My lord, the order of injunction, which I got to buy page 20. Page 22. No, 20 now.
No, Mr. Chatterjee, first appeal is before this court.
Yes.
Sorry, first miscellaneous appeal is before this court. So when the first miscellaneous appeal is coming, I think that will be the end of the matter.
That should have been the end of the matter, my lord. But then now the police help has been granted. Every day the police
Mr. Chatterjee, there are two things. One is status quo
police
order.
is not going.
Status quo order is there.
My lord, your lordship doesn't touch the status quo order, records my undertaking I will not construct, but police cannot go into my house.
Staying will be amounting to finally allowing.
The police help kindly stays.
That is the difficulty.
Lord, if it
Where
goes
are the parties? Please serve without hearing.
But then
without hearing, it's difficult because
allow.
Mr. Chatterjee, it will be amounting to allowing the civil division.
My lord, if it
because
was
staying, because the finally it will also
I'll tell you, your lordship. If it was the injunction application, I would not have, my lord, in any manner, my lord, prayed for an interim order. This is allowing the police help. The police goes, my lord, to my house every day.
No, I will record your submission that according to you, you are in possession and the order of status quo is that you will not be making construction. I will only record that.
After demolition. Have a look at the order.
You are demolishing.
Has been demolished.
Mr. Chatterjee,
on an order of the court.
Mr. Chatterjee, then it's difficult.
No, not difficult. That's the order.
Please serve, then I will consider.
Without that, can you turn to 25 once?
Yes.
Looks to the ordering portion.
Yes, serve the parties. I am keeping it next week.
Just give me 1 minute.
On page 20.
Urgent.
2020.
25.
Yes.
This is the ordering portion, second paragraph.
Yes.
Defendants, the men, agents, servants, and associates are hereby restrained not to change the nature and character of the suit property by way of construction after demolition of the existing building and or any addition and alteration to the suit property and to maintain status quo till the next date now. The next date, my lord, is fixed on 22nd August.
Yes.
Now, kindly sees the impugned order.
You have challenged that order.
Yes.
The first
kindly look to the impugned order now.
Yes.
This is an application of 151, your lordship, sir.
Yes.
Sir, there is no finding I am violating.
Violation has to be there.
No finding. And I went and appeared. Learned plaintiff 151. Yes. Third paragraph. Learned advocate for the defendant opposite party is present today and he stated verbally before the court that he wants time to file written objection. against the petition filed under 151 for police help, and he stated further verbally that he needs to take instruction from his client. Learned advocate for the plaintiff petition has vehemently opposed, and he, if your lordship wants, I shall read on. And further contended that if time is given, there is every possibility of changing the nature and character of the suit property. Yes.
আর এ ফাইল হচ্ছে on 12 June
22/5/2024
আর 151 টা
বেশি দেরি না জর্জ এমনিতে শুরু করতে আমি আসছি হ্যাঁ ওইটাই দেখাতে চাইছি হ্যাঁ হ্যাঁ and then sees the reasoning at number 3
page 55
no certified copy.
Yes,
Kindly looks to the, this is what the finding is. As such, prayer for plaintiff petitioner through his application is allowed because one side is claiming and the other side is violating.
yes. Mr. Chatterjee. Serve upon them. I will hear both of you. I will consider that. That is why I have kept it in the motion in the next day.
In the meantime, if the police goes and obstructs my possession, carries records that possession shall not be affected by this.
Mr. Chatterjee, I cannot hold that you are in possession.
Milord, it is everybody's case that I am in possession. I am constructing. That's his case.
admittedly
Please take me to the
Yes, it's his. He says that I am not constructing.
22nd of. 22nd. Where is that order of status?
Kindly have a look at page 2
page.
of the impugned order.
No. Please show me the status quo order.
Yes.
Status quo order.
Page 22,
The final status quo order.
Yes, sir. 20
So not final according to you.
according to me.
Yes.
23.
Yes, I've got that. Change the nature and character.
Then it is them.
Mr. Chatterjee, any observation will give the police leverage only to implement, because I have to say, apart from that, I think it's better not to make any observation.
It's
I
better.
can only record your submission that you are in possession.
Lord, kindly directs the police not to do anything in the meantime.
Mr.
The way
Chatterjee,
it is, let it be.
Chatterjee, they can, they have to implement this order. If according to you, they cannot disturb your possession. On the other hand, they have to implement this. That means in a direct way, I am asking the police.
Very well. Kindly directs the police not to enter my property.
I think it's better. I can only record your submission that you are in possession. Mr. Chatterjee, যেখানে সাবমিশনটা করেছেন না সেখানে একটা করে দিন। Mr. Chatterjee, learned senior advocate further submits that taking advantage of the
early.
9th, only next week. Because 7th is the monthly list. That is why I've kept it in 9th. And and the first miscellaneous appeal is also going to
Try
appeal.
and get that.
Yes.
For the petitioner, my lord. Here, my lord, I have challenged the order of the municipal building tribunal, my lord,
Yes. What
where my
order
stay has been rejected. Stay has been rejected. Stay of the order of the demolition. My lord, order of the demolition was passed.
Show me the order of demolition.
My lord, my lord.
What is the allegation against you, Mr. Dev?
My lord, kindly come to page number 33.
What have you done?
My lord, I have done my predecessor, my lord.
Where is the order of the
order of the demolition, my lord? Page number 33, my lord.
Page 33 is the order of the tribunal. Please show me the order of the special officer building.
Special officer building, my lord, in page number 23. Ex parte order passed, my lord, against me. This is an order passed ex parte, not making me party. But the party were different. We are the leasee of the property, and they are the sub-leasee. The person responsible, which was indicated, they are the sub-leasee.
Mr. Dey, are you disputing that there is a tin shed in the open space?
Yes, that is a plan, my lord. It is a plan. 1981, my client, my lord, was the leasee in respect of a deed of lease.
Show me the plan.
Yes,
That the plan
is
says
here,
that the tin shed.
Yes,
you can
when we
construct
come
on
to the lease deed first, in page
lease deed. Show me the plan.
Plan is here, my lord. Plan is here, I have annexed from page number 64, my lord. The relevant portion is in page number 66, if your lordship come.
Who are you?
I am the leasee of the property.
No, you are not Bansal Agro Beverages.
No, no, no. My lord.
What is your name?
My name is Venkatesh.
Who has leased the property in your favor?
My lord, in the year 1981.
Who has leased
Yes,
this?
yes, my lord, I am coming.
Bansal Agro?
No. My lord, Rajshekhar Roy, Shashanko Shekhar Roy is the leaser. Page number 45, 49 of my lease deed kindly comes, my lord.
40?
49. Rajshekhar Roy and Shashanko Shekhar Roy were the lessor, and leasee is Shri Venkatesh Construction Company. It is my client, the petitioner here. My lord, then my lord, come to page number 50 and third paragraph. 53rd paragraph.
Show me the schedule.
Yes. My lord, kindly come to 50. Then I'm coming, my lord. By virtue of the intenture of the lease deed dated 21st June 1966 made between Vishwanath Roy, therein described his lessor, one part, and Aram Jonas Gaspar. Subsequently, it was given to Gaspar, Mr. Gaspar, who was, your lordship, fine. Then, my lord, come to page number 51, next page.
So you are in occupation of that tin shaded structure.
The entire building along with tin shed. I'm coming. But kindly come to next page, page number 51. The plan was there. Page number 51, second paragraph.
Yes, Mr. Ghosh, you are appearing. Mr. Ghosh, only one thing. There is an order of demolition. Only one.
Yes.
Now the one thing is
Because the appeal is pending.
indeed
every case to satisfy, when I want to mother, if you have been of the by me say, to satisfy, when I have to look at it. But as I do my lord, for this is concerned, there are going to be other constitution in the ground floor, here portion of the building.
Ground floor, yes, open space.
Open space, man. Where open space?
Yes, yes.
Take vacant. Because
Has to be open space, you cannot cover.
No, no.
As I will understand, because another case gonna take you to this court, but at the construction of the roof, that has been directed to be developed by this court. Now, this is
No, this order is only with regard to the open space.
Man, in open space, there is a
the ground floor.
Is the ground floor.
but there is a plan also.
That is not under challenge here.
Yeah. This other key portion, my lord, I had the occasion to look into that because it's a 401 proceeding was initiated because of finding the making of construction in the rear open space of the building. Rear open space is to be, my lord, kept vacant all the time because that was found to be, my lord.
He says that the plan was sanctioned.
Yes, man.
Because if the plan is sanctioned, definitely my plan will not ever go. If the plan is sanctioned, we
Man, page number
Give him a
6.
copy.
Yes,
Give him a
sir.
copy.
Man, kindly page number 6.
Please give him a copy. I'm keeping it tomorrow.
because of the
Man, tomorrow have
after the order is
tomorrow difficulty. Day after tomorrow. But tomorrow I not be here.
even if the order is refused by the tribunal, even they were under the notices given, there is no scope by the authorities to proceed for demolition.
But Mr. Ghosh, there are two aspects of the matter. The tribunal is insisting over the matter. So, rightly or wrongly, he has approached the tribunal, who is the authority under the statute. So, the tribunal will test that order. Now, if in the meantime, the order is implemented or executed, so the appeal becomes infructuous. That is why there are two ways.
Because it is at the end of the day, the appeal or if the deposition is rejected, it will be said that nothing remains to be considered. Because of refusal of prima facie, if he can satisfy, therefore something is here to protect. That possibly, my lord,
Mr. Ghosh, only one thing. The appeal is otherwise ready for hearing. If I direct the appeal to be disposed of, till that time, don't execute that. Yes, and the order I find, the appeal hearing has been fixed on 10th of December.
On
I
Mary.
can also prepone the date.
nothing to worry because nothing will happen within Singapore of 7 days. Because action is taken, notice is taken, at least for 50 days there.
All right, so I'm keeping it day after tomorrow. When this matter is taken up for hearing,
অন্য ব্রিফের কাগজ ঢুকে গেছে খুঁজে পাচ্ছি না Item number 24, my lord, I victory the petitioner tenant.
Yes. Petitioner tenant. Yes, what
Petitioner
happened?
has made an application for
Mr.
repairing.
Chatterjee is smiling. Yes, Mr. Chatterjee, what is there?
Repairing application has been turned on by the learned court below. Only by recording of the reasons are in essence of a clear pictures.
How can it be done? In the absence of a clear
Kindly see
picture?
these photographs. It has
That I
become-
cannot, from here I do not know.
It has become impossible, my lord, to carry on the business. My lord, kindly see for a moment, my lord. Kindly see this photograph.
I cannot decide from here.
Only
Argument has been fixed, Mr. Ghosh,
but
nothing will,
9th is the final date of argument.
nothing will be done. And
At my own cost, I shall repair the premises.
9th of
9th of July.
9th of July, please wait. Or after that, do whatever. See the fate of 9th of July.
In the meantime, I may be permitted to carry on the repair work.
Mr. Ghosh, you have not brought,
Water.
the finding is correct. I can only consider the finding, nothing more than that. Moreover, your evidence has also been closed. It's a eviction of a tenant.
Yes. 2G
That
has
was-
invoked. 2G has come into.
This application under Article 227 of the Constitution of India
May I humbly submit something, my lord? Order 7, Rule 11 rejected, against that 115A was preferred. That is also rejected. Now they have annexed the certified copy of the 115 capital A. But the Order 7, Rule 11 original rejection certificate copy is not annexed. Kindly takes up after a week, I will not produce the certificate.
Where is the, you have given the photocopy is there?
Photocopy is there.
Procedures.
Lordship, I led by my senior Mr. Tithango Dhali. We have filed, I am for the respondents, all the
There's
respondents.
the caveat.
Yes, we have filed a caveat in respect with the order passed by the Malda district judge, but no notice has been served against upon us. Till now.
Yes, Mr. Banerjee. What is your name? Parvez Alam?
Yes, Lordship.
Mr. Banerjee,
This is the copy of the caveat. Lordship, this is the copy of the caveat.
What are you doing? The caveat is there. It has not been served. Look to the
briefed in the matter, my lord, not from my chamber, but Lord, I will serve and come back. Kindly takes up the next week. I'll come back with the certificate copy also.
What is the Order 7 Rule 11 for?
11 for contention was filed under Order 7 Rule 11F. Non-compliance of Rule 9, but that is not the case. Wrong description. Point is that suit was previously dismissed for default in presence of the defendant. So Order 9 Rule 9 bar comes in. Subsequent suit filed. Subsequent suit is bar under Order 9 Rule 9. They have argued on res judicata that since suit is dismissed, is res judicata. Court has said no, it cannot be res judicata. Issue is not decided. But the bar under Order 9 Rule 9 has not been considered. But I'll have to once consider the plaint and come back, because first reading.
That is your application.
But Lordship, we have went to the LRTT, but they have told us to file a suit against in the civil court.
Where is your application under Order 7 Rule 11?
136, my lord.
What is the suit for?
Suit for partition. I'll be candid.
This is for partition, Mr. Banerjee.
And I'll be
Fresh cause of action.
And the plain, I'll be not candid. If your lordship comes
Then
to
I'm
plain,
deciding this. Order 9 Rule 9.
Of the plaint also possibly it is not there, my lord. I just got the brief, my lord. Plaint, it is possibly this averment is not there in the within the plaint also. We can look in the plaint and the supporting documents, my lord. Possibly it is not there. 127 is the plaint.
127.
127. Lord. This specific averment is not there in the plaint. So,
and even assuming that you are allowed to take that point,
my lord,
partition suit, even if it is the earlier suit is dismissed for default, it's a recurring cause of action. It's not on the same cause of action. Separate suit is maintainable.
In case of partition.
In case of partition, it's a recurring cause of action. Even then,
the courts misdirected. Courts only went on res judicata. But suppose suit is decided, in that section 11 would have applied. Partition suit if it is rejected, because interstate.
Partition suit, if it's not rejected, if it is a final decree, it goes to that. If it's even if it is rejected, so fresh cause of action you can file. But once a preliminary decree has been passed, then there is a bar. Otherwise, cause of action remains.
For partition.
That's the distinction. If it's a recurring cause of action, so the bar under Order 9 Rule 9 is on the same cause of action, you cannot. That's the bar under Order 9 Rule 9.
They have to show me that different cause of action, subsequent cause of action.
Yes.
There are other facts.
So those are the facts can be decided.
May I humbly submit this, my lord? Kindly, my lord, hold that, my lord. I find from the four corners of the plaint this particular averment of the dismissal is not there in the four corners of the plane. Kindly give me liberty, I'll take up appropriate application under order 14 rule 2. Let this issue be decided. If it is same cause of action, then it is barred under order 9 rule 9. If they can show that no, they have made out a subsequent cause of action, then
Yes, it says precluded from bringing a fresh suit in respect of the same cause of action. That's the bar.
kindly give me liberty, I'll take out an application under order 14 rule 2 because the pleading is not there in the plane.
Appropriate application, yes. What do you say to this?
Lordship, without servicing of the notice, Lordship.
Give him a notice because
I'll give a copy and come back.
When?
Sir, whenever,
October,
Lordship, at least 2 weeks time.
At least 2 weeks time. Why?
Lordship, I need it for preparation, Lordship.
You could not follow the code. You
Lordship,
could not
my
follow the
senior-
code.
My senior has
It's
instructed.
to junior is depending on his senior. অত সময় লাগবে না তোমার favorite
When this matter Yes, 26.
My lord, I am praying for 2 weeks time for the petition.
Yes, why?
Because petitioner wants to appoint some another senior advocates for this.
So I'm directing it to go out of the list. You take your time. The learned advocate appearing.
Seven, my lord, I appear on behalf of the petitioner. My lord, there is an application for expeditious disposal of my lord. Lord, I am the plaintiff landlord, my lord. I have filed a suit under section 6 of the West Bengal Premises Tenancy Act, my lord. Thereafter, my lord, kindly, my lord, comes to page 18, my lord. Operating part is at page 23.
Page
23.
Yes. What do you want to show from page
My
20?
lord, the defense has been struck off.
Yes. Any difficulty on my part to take up this matter?
I have checked up, my lord, no difficulty.
23. Yes.
My lord, kindly, my lord, please, my lord, the defense has been struck off.
Yes.
Thereafter, my lord, the suit proceeded to ex parte argument stage. Now, my lord, kindly, my lord, comes to the certified copy, my lord, order number 111.
21st of July for hearing the application for ex parte vacating petition.
Yes.
So that has to be considered.
Yes, that has to be considered, my lord. Suit proceeded to the ex parte argument stage, my lord.
Contest the application forcefully. This application under Article application. Yes, next.
I am for the petitioner, my lord. The petitioner is the judgment debtor appellant, and impugn order is the quantum of the occupational charge. Now, occupation petitioner is occupying 96 square feet, one dilapidated 50 years room, and 22 square feet veranda. It appears from the commissioner report. Total amounting to 116 square feet. Now,
115.
116 square feet.
116.
Yes. Now, on the basis of the query report of
What are you doing there? What are you doing there?
residential,
Residential, one room.
one room and veranda.
Which area?
Ramdulal Sarkar Street. But it is kindly consider the query report. The query report is for the flat or apartment, because there is no provision to find out the valuation.
What is the market rate of rent at that
That was not placed there.
I'm asking you. Did you place?
I failed to place.
Then, but if you have failed to place any document, the learned trial judge was
kindly consider the photographs of 31, page number 31.
Dilapidated building, please vacate. Please vacate. It may collapse at any point of time. Please vacate. It's better to vacate.
My lord,
and if you get an accommodation at a lesser rent, why are you sticking to that? Less than 4,000 you will get in that area.
My lord, initially,
This application
Item number 29.
For the petitioner. Lordship, it is found that one caveat has been filed. So please permit me to serve the copy to the caveator.
Yes, what is the impugned order?
In order that the opposite party number one has got an ex parte decree on title suit number 662 of 660 of 2020.
Yes.
On that basis, they have executed on that order. So I may be evicted. And also I have
What is
filed
the impugned order? Which order you are challenging?
title suit number 660 of 2020 and
The learned advocate appearing for the petitioner.
Item number 30.
In this matter, Sonak Bhattacharya is appearing on behalf of the petitioner, my lord. Due to some personal difficulties, my lord, kindly release the matter.
Yes, Mr. Ghosh, please ascertain. Pass over. Appearing. Ashun. Ashun. Since I'm not in.
Item number 31.
Lord, I am for the petition.
Yes.
Lord, I am the landlord and the plaintiff, my lord.
Yes.
I have filed a suit in the year 2010. Now, my lord, since 2019, my lord, I am suffering from blood cancer, my lord.
Yes.
Now,
what is the order under challenge? 25th of March.
25th of March.
So the miscase was miscase under order 9 rule 9 was dismissed.
Yes, my lord. That
is an appellable order.
No, my lord.
No. Order 43 rule 1 C. Have you seen that?
My lord,
check up. দিয়ে দিন তো বইটা।
My lord. But my lord, only one submission, my lord. The main order that the main suit that was dismissed, my lord, by order dated 11th of.
For that you have filed an
order 9 rule 9.
Order 9 rule 9 is an appellable one. 32. None appears for the petitioner at the time of call, no accommodation. Number 33.
And for the petitioner, my lord, very short point, my lord, the misappeal was filed challenging the ad interim order on 11th of March 24. The respondents are opposite parties that they are contesting, either they are asking for adjournment or the court is busy. My lord, the next date is fixed on 8th of August. Let it be heard and disposed of on that same date.
8th of August.
Yes.
This is the miscellaneous appeal against order 39, rule 1 and 2.
Ad interim order.
This application under article. Number 34.
34, my lord, I am for the petitioner.
Yes.
My lord, petitioner, my lord, the wife, my lord, he filed application in the year 2013, my lord, under the Protection of Women from Domestic Violence Act. My lord, that my lord, application, my lord, after conducting trial, my lord, magistrate passed an order and in favor of the petitioner. Then, my lord, against that order, my lord, petitioner and husband, both are, my lord, challenging appeal before the Honorable Session Judge. And against that order, Honorable up to High Court, that was, my lord, in favor of this petitioner. Now, my lord, husband, 2018 filed a title suit declaring that this petitioner is not his wife. My lord, that suit, my lord, this petitioner filed an application on maintainability ground, page 17. My lord, he stated that as my lord, Domestic Violence Protection Act, after taking evidence that was concluded that petitioner is the wife, and London Magistrate granted my lord maintenance, and up to Honorable High Court passed the order in favor of the petitioner. So this suit is not maintainable on the limitation ground, as well as similar fact, my lord, criminal court conducted trial and passed the order in favor of the petitioner. On London Magistrate, my lord, London Civil Judge Junior Division, that application was rejected. Against this, my lord, petitioner filed this application.
Can a criminal court declare
Criminal court, my lord, taking
that there was a valid marriage? Can a criminal court declare with regard to that?
Well, issue is, my lord,
maybe
husband challenged that the
maybe
petitioner is not his wife.
is neither here
But,
nor
my lord,
there.
taking
Show me
evidence,
that the criminal court is authorized to declare that the petitioner is the legally married wife.
taking evidence from both sides, that is, my lord, confirmed that the petitioner is wife.
Show me that the criminal court has jurisdiction. Show me that. Show me that.
Then, my lord, 2013, my lord, incident cause of action arise. Well, suit filed 2018, or declaration suit, my lord, to file within 3 years. That also, my lord, ground of limitation, my lord. Or 2013, my lord, has been contested.
Where is the order of the criminal court which you are trying to rely upon?
My lord, that, my lord, maintainability ground petition I have disclosed, my lord.
That
stated, my lord.
Maintenance order has been passed.
My lord, maintenance order has been passed. My lord, husband filed an application that application was not maintainable as he is not his wife. My lord, that application was rejected. My lord, up to my lord session judge and up
Where is
to
this
honorable.
plaint? Where is the plaint?
My lord, plaint, my lord, page my lord 13, my lord, page 11, my lord, plaint.
And where is your application for not that it is the suit is not maintainable?
Page 17, my lord.
Yes. Anything more? This application under Article 220 Next matter.
Item number 35.
Yes.
But the decree holder is the petitioner before your lordship. But here, my lord, while assessing the occupation charge, the court has appointed, my lord, the advocate commissioner, which was, my lord, prayed for recall, that was turned down by the next order impugn. My lord, a suit has been initiated by my client on the ground of subletting. Suit decreed. My lord, the person who is in possession, the subletting, he, my lord, filed a suit. That suit has been defeated regarding declaration of his tenancy right, upheld up to this honorable court. My lord, initial round of litigation of that subletter, my lord, he has filed an order 21 rule 99 that was turned down.
So what is the occupation charges fixed?
No, my lord, initially that was, my lord, fixed, my lord, without any, my lord, the stay has been granted without any precondition.
Thereafter condition has been imposed.
No, I have paid for recalling of that order. The first impugn.
So opposite party numbers 1 and 2 are directed. Oh, this is the commissioner fees.
Yes. My lord, I prayed for recalling of this order, stating, pointing out.
No, why advocate commissioner has been appointed?
My lord, for the purpose of, my lord, there is no dispute with regard to the area of occupation. We have, my lord, filed the document suggesting what should be the market value, including the valuation statement, my lord, order of this honorable court in respect to the same locality, as well as, my lord, one of the rent, my lord, shown in the brickfield, magic brickfield, my lord, in the internet website. That was given. In spite of that, while, my lord, passing the order, the learned judge appointed, my lord, the advocate commissioner. Again, we filed a recalling application.
Yes, CO 3892 of
I have seen, my lord, I have seen that order. There, the area of occupation is in dispute. My lord, your lordship,
I'm bound by that order.
But if it is area of occupation is in dispute, here it is admitted. Kindly takes up one page. Kindly takes up this page.
Show me that order passed in CO 3892.
Well, kindly once takes up page 59. This is a suit initiated by Arun Gupta, where he defeated. Page 59 is the schedule. He himself mentioned the area of occupation.
Sir, Mukherjee, this is that Arun Gupta.
No, Arun Gupta.
For
no, that
subletting.
He is for the landlord. This is not the same. This is not the same. That is not the liquor shop. Your lordship is. No, this is not the same. But page 59, they themselves in the schedule. And I have, my lord, provided. It is not that the court has not been assisted with the, my lord, substance. I have provided, my lord, the locality, what should be the rate of rent, order of this honorable court fixing the occupation charge in respect of similar locality area. Wherein 10,000.
What is the miscase for?
Miscase order 21 rule 99 again. Once, my lord, the person who is the sublet.
Third party.
Now it is the third party whose right has already been adjudicated by this honorable court. He is claiming from someone. This honorable court already had his predecessor died issueless. He is not the heir.
Show me that the court finds that there is a dispute with regard to the area of occupation.
No, my lord, that is also not there. Kindly takes up, my lord, the order dated 29th of March 2025 once.
There is substance in the argument.
Not the stay of operation of this order by virtue of which, if the commission held, my lord, unnecessary exercise. That's why.
At whose cost?
My lord, at the cost of the, my lord, mine.
Your cost?
Yes. my cost.
There shall be an order of
I appear on top of the petition. Now, there was a caveat which was filed. We have already served pursuant to the caveat.
There was the caveat.
Yes.
Who's
I
for
want-
the caveator?
Lordship, I'm told.
Choitali Chatterjee.
Lordship, may I briefly state, Lordship, I am the defendant in a suit for eviction, Lordship. The default, Lordship.
What is the impugned order?
Yes, my lord. My lord, may kindly see that the rent which I was depositing before the rent controller has not been taken into account. That is the first point. And they say that the name of the plaintiff has not been put correctly. Now, my lord, may kindly, I will not trouble my lord with all the documents. Kindly take up page 87. That is my first deposit before the rent controller. And my 7172 both has been disposed of without giving me an opportunity. I was already complying with the order. My lord, may kindly take up 87.
Give me a minute.
My lord.
Post 1431 BS. For how many months you did not deposit?
Lordship, I could not.
How many months?
That both. I don't currently.
From post 1431, for how many months you did not deposit?
Could be, my lord, I'll just indicate.
How many months? Where is your application number 151?
Yes, my lord, that is at page 100 and
102.
yes.
How many months? You have not stated that in your application also.
My lord, I just calculate. Lordship, immediate on the default lordship, we took out this application, and after that we could not. And thereafter it was taken up, lordship, on March. The impugned order, my lord, has already seen.
From post 1431 till how many months?
That is what.
Why?
From that day,
Lordship, they did not. Lordship, that deposit could not be made. Prior to that, lordship, I was completely diligent.
Maybe after that, for this, how can it be condoned? There is no provision for condonation.
My lord, the thing is,
taken out that there was a 2 days delay. Kindly extend that.
that was kept pending. That
prevented you from depositing subsequent months.
The subsequent one they did not take because since there is a
You are depositing in the court. Who will not take?
court says that if there is a breakage of 1 day until
Show me that is the finding. That is not the finding.
that is not the finding, my lord.
Show me that immediately after post for 1431, you have approached the court. Where is that? You have not approached the court.
Lordship, that is my application at 100 and.
No, how many months? When did you file this application?
Lordship, immediately when they refused to accept it, lordship, immediately thereafter I took out that application.
What is the Bengali month when you file this application? Because you are a tenant according to Bengali month.
Yes.
Yes. 1431, post 1431 was the default. When did you file the application?
there was a delay of 2 days. When this application was filed, when we went to deposit the charge, the department said go and take the permission of the court. There is a delay of 2 days. So that's
Lordship, there wasn't upon instructions, lordship, what I submit is, lordship, there wasn't any significant delay. Soon after they made an attempt to deposit, they said that we cannot accept it. You take out an application and get the leave of the court. That is when we had preferred this application, lordship.
By the
Item number 37.
Yes. You are appearing, Mr. Trivedi?
Sir, my client will be
Yes, yes, Mr. Pal.
My lord, the petitioner, defendant number one, purchased a shop room from the brother of the plaintiff.
What is the impugned order?
Impugned order, my lord, the ad interim order was passed, my lord. I am the owner of the property, purchased from the brother. My lord, as per Apos Montonnama, my lord, the shop room was in his, as per his share, but the ad interim or injunction was passed, my lord, that you cannot enter into the shop room, you cannot change the nature and character of the shop room. And that was affirmed by the appellate court.
Where is the order of the appellate court?
My lord, after page number 157.
22nd of April 2025.
My lord.
By the order impugned.
Stay.
What stay? Injunction contested stay.
Item number 38.
13, my lord, I am for the petitioner. Defendant is the petitioner before my lord, my lord. Defendant is the petitioner. My lord, with valid sanction plan, my lord, plaintiffs are our neighbor. My lord, with valid sanction plan and my lord, no objection from the plaintiff, I started construction. Now, my lord, the plaintiff filed a suit. In that suit, my lord, status quo order has been passed. My lord, I filed my lord, the vacating application that was rejected. And my lord, the order 26 rule 9 filed by the plaintiff that was also rejected. Now, my lord, I am praying for my lord, kindly direct the court below, my lord, hear out the injunction application.
Injunction application is pending.
Yes, my lord, the
Order that and rule 4 dismissed.
yes. And
What is the next date fixed? You have filed the written objection.
Yes, yes, my lord, of written objection.
What is the next date fixed?
My lord, 27th was the last date. On that the matter was adjourned.
27th of June.
Yes. Now the next date is my lord.
Application under
My
article.
lord, next date is the November 3rd. My lord, kindly prepone this date.
Prepone
My lord,
not from here.
I have taken loan, my lord, the bank.
Preponement not from here, from there. I can give you liberty to apply for preponing. Choice is yours. Either on the date fixed or you apply for preponing there. You have two alternatives. Choose one. I will accept that.
Then my lord, preponement, I have to wait, my lord. Preponement, my lord.
This application under article
41 is also same, my lord. Suit number is
41.
Original.
Item number 41, same order.
suit number is
To the suit number, date is also same. Yes, yes.
I have my lord. Apologize, my lord. To move and unlist, my lord, listing today, my lord, what has happened, my lord, just 1 minute, my lord kindly takes up, my lord, then whatever falls. My lord,
No, no, কোনটা দিলেন? এটা leave নিচ্ছে.
Injunction granted ad interim. On the next day, when I entered appearance, an application under 151.
You want leave?
Lord, because police will come and dispossess me. They have given me notice yesterday that we will implement the order passed under section 151. Order not to.
Where is the impugned order?
My lord will kindly come to the certified copy. The order is dated 15/5/2025, my lord, the last order. Lord, my objection was there, my lord, that I am in possession. In spite of that, the learned court granted an order of implementation of that order. My lord, will kindly see.
Implementation of which order? 1812.
My lord, before that, my lord, will kindly come the status quo order. I'm sorry, not to interfere with, my lord, just an order before that. 18/12/2024, lordship will kindly get. This
All right.
plaintiff move.
You file it, it
My
will
lord,
appear
My lord, well,
not
the
today.
police.
You file it, it will appear, give a date, short service and at leave দিয়ে দিন.
My lord, I'll be disqualified.
Why? I've seen the,
My lord,
Mr. Trivedi, I've seen the order of injunction.
No,
You
my
cannot be dispossessed by that.
My lord,
Restrain from disturbing the peaceful possession.
My lord, will kindly see the police threatening letter we have received.
Maybe. If the police does something,
My lord, will then remember my faith, my lord. If
yes,
anything happens, my
you file with short service. Tomorrow you can, it will appear in the list.
My lord,
Leave to file with short
this
service.
is, my lord, no caveat is there, my lord. My lord, then also we'll serve, my lord.
No, if there is no caveat, you
No
need not
caveat,
serve.
No caveat. My lord, yeah,
Leave
we
to
will-
file
my
with-
lord, let it appear tomorrow. I will give the number in the course of that.
Mention that in the presentation form. I'm giving you leave to file with short service. Short service is দরকার নেই, এটা তো রিট নয়. Leave to file to appear tomorrow.
Great.